So, good morning, good afternoon, good evening to everybody, depending on from where you are joining us today, including our speakers who are joining us from Singapore and from Melbourne today. So this is really covering the whole region of the Indo-Pacific. I'd like to extend a very warm welcome to a new edition of the Franco-German Observatory of the Indo-Pacific, and to today's webinar. I believe it's the 18th in a long series, which will focus on China, Vietnam, legal development assistance as foreign policy, question mark or not, you'll tell us. Since earlier this year, I think the Indo-Pacific Observatory has alternated country perspectives, which has been its mainstay, looking at views and accounts of countries in the region, including major countries, middle and minor countries, smaller countries, and also the EU. And on the other hand, so-called transversal perspectives, such as military buildup, connectivity. Last time we had something like minilateral formats, so really key issues that pertain to the whole region. And today, it's in fact a mix of both perspectives. We have countries, China, major player, and Vietnam, one of the minor ones, but ambitious to grow. And their bilateral relations, China and Vietnam, and how they interact, but we also look at the role of legal development assistance and of law at large in shaping the geopolitics and geoeconomics in the region, right? So I'm Heike Holbig, working on Chinese politics at the GIGA, and I'm very happy to chair today's session together with my co-moderator, Jérôme Doyon, a junior professor at the Center for International Relations, Erie, at Sciences Po Paris. The Erie and the German Institute for Global and Area Studies are regularly co-organizing this Indo-Pacific Observatory, and we are sharing chair and co-moderator roles. So I'm very happy to lead you through today's event together with Jérôme. Will in a second also introduce our two speakers. Before handing over to him, let me just mention that as we have two inputs, two speakers, if comments, interesting questions come to your mind during listening to them, please don't let them slip through your fingers, but use our chat function to note down your questions, and after both inputs, we will then, Jérôme and myself, we will then group and address the speakers with your questions. Okay, without further ado, Jérôme, would you please give a short introduction to our speakers?
Thank you, Heike. Yeah, it's a pleasure to take part in this webinar series, and it's also a pleasure to welcome, as part of this webinar series, two speakers today. So we have Matthew Erie, who will speak first, from the University of Oxford, who is both an associate professor of modern Chinese studies, as well as an associate research fellow of the Socio-Legal Studies Centre, and if I'm not mistaken, is currently visiting at the National University of Singapore. So Professor Erie is trained in both law and anthropology and studies comparative Asian law, is written on Chinese law, Islamic law, and comparative international law. We are also pleased to welcome a second speaker, Ha Do, who is a research fellow at the Asian Law Centre in the Melbourne Law School, and his research focuses broadly on legal reform and transplantation in transitional socialist states. So we're talking about China and Vietnam, of course, today. Is also looking at comparative and international labor law and constitutional law more broadly. Interestingly, so they have both worked together as part of a project led by Matthew Erie and funded by the European Research Council, titled China Law and Development. I guess this is the 5th year of the project. Is that correct? So it's an interdisciplinary project bringing together actually a very wide group of international scholars to try and better understand the role of law in China's global development, Chinese globalization, including how China is shaping international law and how it also impacts the internal legal and regulatory orders of other states. And so we're talking about Vietnam today. Of course, it's a fascinating topic, and actually the website of the project is very well done and very rich. So I suggest you go have a look. There's a lot of publications there linked to that project. And so they've both taken part. Ha was a postdoc as part of this project before he joined the Melbourne Law School, and together today they will present us part of the Vietnam leg of this project. So we're very keen on hearing what they have to say. So I give you the floor. As we mentioned earlier, you have around 10 minutes each. Please, Matthew, and then Ha. Yeah.
Thank you so much, Jerome, and thank you, Heike, for having us. It's really a pleasure to be here. So I'm going to try to keep it as short as possible. Really want Ha to have opportunity and time to speak. But let me just begin by, again, sort of briefly introducing the larger project. I'm then going to hone in on China's economic statecraft and foreign policy in the Indo-Pacific region and Southeast Asia in particular as we see it. And then I want to talk about the legal development issue, and then Ha will focus in on the Vietnam question. So as Jerome said, we are part of the China Law and Development Project based at the University of Oxford. It's a 5-year research project, which is looking at how China is using law, thinking about law in the terms of its global development projects. So it could be Chinese law, it could be non-Chinese law, it could be UK law, New York law. But we're very interested in the legal dimensions of what's happening. And the legal aspect is often sort of marginalized, I think, in the larger analysis of this question of global China. And as Jerome said, we work through an international interdisciplinary research team, primarily scholars who are trained in law and the social sciences, so law and anthropology, law, sociology, law and political science. And often the focus is working with scholars who are from these countries, right? So we want to be engaged with people who are immersed in and embedded in the local conversations in terms of how China may be shaping their jurisdiction and the larger sort of knock-on effects of a growing Chinese presence there. So the question of China's economic statecraft is a very important one for the project, and I think, you know, we can see that the Indo-Pacific region and the ASEAN states in particular are a challenging area for China. So when we think about China's relationship with the global South, oftentimes we think of Latin America or Africa, maybe Central Asia, and there's a certain pattern of behavior that I think the ASEAN states break away from, because they have their own sense of their economic development. There's a variety of levels of socioeconomic development between the states. For example, Vietnam being relatively developed compared to other countries in the region. And I think, you know, this poses certain challenges for Chinese who are engaging with these particular countries. Very recently, we've seen China in the post-COVID era really trying to make, I think, a big a statement about its relationship with the global South. So we saw in March of this year, China mediating between Saudi Arabia and Iran. We saw Lulu from Brazil coming in April. And then just recently, the Xi'an summit, right, featuring leaders from Central Asian states. So again, I think these are all examples of areas where the Chinese government is really focusing on. ASEAN, I stand by the statement, really, I think is a different story. And so we need to kind of zero in on the complexity of that region and how China is engaging with particular states bilaterally within the region, but also potentially multilaterally through the ASEAN platform. I think, you know, it's fair to say that elite capture may be one dimension of the story, but I think it happens differentially across the states in the region. And China's approach to foreign relations and economic statecraft reflects this. So in terms of the modes of engagement that we see, right, in terms of how China is interacting with states in the Indo-Pacific, I think there's, generally speaking, 4 main buckets to consider. The first is influence operations, and this would be Chinese engaging with local media or China's own media operations, which are cross-border in nature, the United Work Front, the Tongjianbu, which also has a presence in these countries. And also, let's not forget that the Southeast Asia is really the heartland of the Chinese diaspora in many ways. Now, oftentimes they're sort of dovetailed in thinking about, the Chinese state, but obviously Chinese diaspora have their own goals and intentions and interests, and they shouldn't be automatically assumed to be working with Chinese authorities, right? Oftentimes they're working against. So again, a very complicated relationship. Think about here in Singapore, it's very complicated. The second bucket would be economic coercion or trade coercion, and this is the threat or act by China as the home state to disrupt economic exchange with a host state, say in Southeast Asia, unless that state acquiesces to some demand that China is making. And so effectively what happens here is China could threaten to cut off access to its market, which, as we know, is one of the largest markets in the world, often via trade retaliation. So the specific mechanism would be some kind of trade measure, tariffs or customs that are imposed. The broader definition of trade coercion or economic coercion could include things like economic sanctions, which we see now states, including China, but primarily the US, using quite robustly, and also cutting off loans, right, as a sort of punishment or penalty. We've seen a number of case examples of this: Japan, Norway, the Philippines, South Korea, Mongolia, and Australia, where the Chinese authorities have used these tools as a example of economic coercion, because those states, either said something against China's interests or acted in a way that was against China's interests. The third bucket is inducements. So not thinking about punishments or the imposition of penalties, but rather attracting the interests of host states and aligning them with China's own interests. And I think law is one interesting way to think about inducements, and I'll talk about that in a moment. And then the last bucket is a very interesting one. I would call it the unintentional aspects of economic statecraft and as a mode of engagement. And what I mean by that is, China, just by the sheer size of its market and its economic footprint in these smaller or weaker states, can have unintentional knock-on effects. So it's not necessarily that the Chinese authorities are requesting this, or they're driving towards it, or they're intentionally acting towards it, but rather local counterparties may be responding in such a way that is beneficial to Chinese companies or Chinese authorities. So for an example here would be exemptions from certain public procurement procedures, something that we've seen across a number of states where China is very active in, and it's not necessarily the Chinese companies or investors that are asking for these, but it's simply granted to them because local authorities want to entice more Chinese FDI. So what are the goals or effects of these various methods of engagement in economic statecraft? Well, affecting political elite behavior, right? So shaping the responses of political elite. I think that's first and foremost, but also secondly, influencing local media and popular perception of what China is doing is also a very important dimension of it. Impacting local civil society and academic knowledge production would be a third category. And lastly, shaping, influencing, or nudging, if you will, legal development or underdevelopment. So that could be an effect as well, the Chinese presence is actually underdeveloping a host state legal system. And I think there's a couple of categories underneath this last one in terms of legal effects. One is the commercial or pragmatic effects, so risk mitigation. So Chinese companies are incentivized to reduce the types of risks that they face in a host state, and so they might use legal means to do that. There's geostrategic elements as well. For example, through the Belt and Road Initiative, creating legal harmonization across borders, which can help move Chinese capital, goods, and laborers, and also align the interests of allies in the process, so China's own ally shoring, if you will. And then lastly, the unintentional dimension, which is thinking about sort of exceptions to the legal regime, jurisdictional carve-outs, which somehow benefit Chinese parties. So in the time that remains, I just want to touch on this important element of legal development or assistance. So the US, the UK, Germany, Japan, they're all well known for providing legal development assistance to developing countries. They've been doing this for decades, right? China is relatively new. It's a newcomer in this space. It doesn't have a formal overarching policy per se, but rather what we see is a loose coordination of different types of actors, official and non-state actors that are operating in this area. So on the official side, the legal and judicial organs are, for example, the China Law Society, the Supreme People's Court, the Ministry of Justice, and others, including, you could include the All China Lawyers Association in that group as well. We also see the legal service providers, the law firms, very active in this area, but then also the businesses themselves, the state-owned enterprises, the privately owned enterprises, the tech companies, the small, medium-sized enterprises are also part of this story. And lastly, I would include law schools and GONGOs, the government organized NGOs. They're all playing roles in this area. On the formal side, the legal development can play a role in terms of legal diplomacy. In particular, the China Law Society, the Supreme People's Court, as they're engaging in conferencing and training of non-PRC judges and lawyers, this can play into the larger bilateral relationship or multilateral relationship with China and these other states. On the informal side, we see lots of networking between Chinese judges and lawyers and counterparts in other countries. Sometimes these networks can lead to substantive outcomes in terms of legislative change and institution building in these countries. And with that, I want to turn it over to Ha, who will tell everybody about the China-Vietnam story and the particular examples that we see of legal development assistance. Ha, over to you.
Yeah. Thank you, Matthew. Very disciplined on time. Yeah, Ha, you have the floor, please.
Yeah, thank you, Jerome, and thank you, Matthew, for setting a interesting general background for my presentation. My presentation is actually a work that a co-author work by both Matthew and me, and it looks specifically at the attempt of the Chinese to transplant its legal model, specifically is SEZ, Special Economic Zone model to Vietnam. But before I start with that story, let me give you some general background about the relationship between China and Vietnam. I would say that Vietnam has a special history with China. The two countries are neighbors, and they have a relation that have lasted for thousands of years. And within those thousands of years, Vietnam was a part of China for almost for about 1,000 years before it gained independence in the 10th century. And since then, Vietnam became a tributary state to China. So the history between the two countries was rather complicated. On the one hand, Vietnam considered China as a model for legal development. I mean, even in the pre-modern times, for legal, political, economic development. On the other hand, China was the main enemy of Vietnam for 1,000 years. Vietnam had to fight against invasion from China from time to time, and I think many of you may know that. Even in contemporary time, the relation between China and Vietnam tends to replicate the past. So on the one hand, we can see that now China and Vietnam are both communist states, and there is a strong tie between the two countries and between the two communist parties as well. The two parties, the CPP and the VCP, they often describe the relationship between the two countries as a sort of like we are both comrades and brothers. So a very strong tie politically, and China is one of the 4 countries that have a sort of a comprehensive strategic partnership with Vietnam. The others are Russia, India, and Korea. So although the U.S. is very important to the Vietnamese economy and politics, it is now only a comprehensive partner. So it's ranked much lower than China within the diplomacy system of Vietnam. And economically, China is very important to Vietnam. It is the top trading partner, and now it is the fourth biggest investor in Vietnam. That's the mainland. If we and Hong Kong is ranked number 5. So if we calculated both Hong Kong and China, that would be roughly nearly $4 billion invested in Vietnam now. And if we consider that, we know that Chinese investors, many Chinese investors use Vietnamese residents to hold their business, or use another entity, say, for example, located in Singapore or Hong Kong or another jurisdiction to invest into Vietnam. We can imagine that China is a very big investor in Vietnam today. But even though there are still ongoing conflicts between the two countries. If we go back to the 1970s, there was a bloody border conflict. The two countries was normalized the relationship in the 1990s, but there are still ongoing conflicts. For example, the maritime and territorial dispute in the South China Sea, and even there like minor border dispute in land, although such dispute as not like reported in the media frequently. So in summary, so the China-Vietnam, Sino-Vietnam relation is like multifaceted. There is strong ties in culturally, politically, economically, but on the other hand, there are ongoing conflicts between the two countries. So that's the background, some background about the China-Vietnam relation. So let's go back to the main story, which is about China's attempt to transplant their law to Vietnam. And actually, this is a quite rare example showing how the Chinese is active in exporting their legal model to another country. So generally, compared with other powerful countries like the US, the UK, etc., China has been more reluctant in doing so. But this is a rare case in which Chinese actors have worked active to introduce their legal model to another country. So, but well, why saying so? I would say that although the China has not been active in exporting their law to Vietnam, Chinese borrowing is extensive within the Vietnamese legal system. But most of the time, it was because the Vietnamese policymakers, they voluntarily came to China as a model to develop their legal system. But this is the case where there is not only like pull factor, but also push factor. So both sides, we can see a match of both from the supply and the demand side. So let me talk briefly about this case study. This is about the a bill which was drafted in Vietnam from 2014 and then submitted to the National Assembly for deliberation in 2017. And the bill, basically, the bill was the bill proposed the development of 3 what they call special 3 special economic zones in Vietnam. One is Vân Đồn, which is situated next to, very close to China, within in the North Vietnam, and then the second is Bắc Vân Phong, which is situated in the middle of Vietnam, and the third is Vân Đồn, which is at the very southern of the country. So both, all of them are coastal regions, coastal and island regions, and the purpose of the proposed law is to create like is to improve the competitive advantage of Vietnam, to promote foreign investment and economic growth, and for that purpose, they propose to develop these three special economic zones, and to realize that goal, the bill has offers some unique regulation and incentives to attract investment. For example, it includes relaxation of licensing conditions and procedures, expansion of land rights for investors, especially foreign investors, including land lease of up to 99 years. It also includes tax and other financial incentive. It includes it proposes special financial mechanism for infrastructure development and easy rules for immigration and expatriates. And the bill will also propose a new model for local government, which was said to be smaller but more effective. And in developing this bill, Vietnamese lawmakers was inspired significantly by foreign experience, and they didn't only look at China as a model. Actually, they looked at several multiple jurisdictions, including not only China but also Korea, the UAE, Singapore, etc. But the greatest attention, if we read legislative documents carefully, we would see that the greatest attention was given to two countries, that's China and Korea. And although it was difficult for me and Matthew to trace how specifically how the Chinese was involved in the making of the bill, because the bill was this bill has become a sensitive topic in Vietnam. It was really hard for us to do that, but from different sources, we realized that the Chinese actor participated extensively in the drafting process. So we can see that, and the actor that was involved extensively in the drafting process was the China Center for Special Economic Zone Research at Shenzhen University. So from the website of this center and government website in Vietnam, we can see that there were many multiple day visits between the two countries. There were fieldwork activities. There were even a 2-week training program designed and operated by this center, and many meetings and workshops, and one international conference with more than 200 participants to exchange the experience between China and Vietnam. And more importantly, we do not only see the involvement of the Chinese actor, we also see that the Vietnamese policymakers were inspired by the Chinese model. And reading the legislation document, we see that there was a strong admiration for China. It was said that China was the birthplace of a special economic zone, although this is not true. China is not the birthplace of this economic model at all. And there was repeatedly China was cited as an example of success for SEZ development, and then we can see a strong emphasis on the role of the government in developing SEZ, and in in doing so, the Vietnamese policymakers they frequently they cited the China as an illustration for why they should follow that. So we see different examples of specific replica of the Chinese model. I don't have time to talk much about that, but let's turn to how the local actor has responded to the bill. During the lawmaking process, however, there was extensive protest. And the protest, primarily the protest came from mostly came from economists and lawyers. And they challenged the bill from different perspectives. For example, they challenged the SEC model in general, whatever it is from China or whether it suits Vietnam or not. They challenged the SEC as a good economic model in general. And then they also pointed out they also questioned the suitability of this model to Vietnam specifically, or to the three proposed SEC. And apart from that, they underlie the Chinese threat. They underlie the Chinese threat. They pointed out that the three economic zones proposed by the bill, they are on important location in terms of in military term, in political term, in economic term, and they were concerned about the possibility that the Chinese may take advantage of the openness of the bill to dominate these economic zones. Despite these oppositions, the bill was still submitted to the National Assembly, and then the protest exploded. So throughout the drafting process, the press came mainly from economists, lawyers and experts. But when it was submitted to the National Assembly, then a lot of people came up and protested the bill, including some National Assembly delegates, including many retired party state officials and political dissidents and independent Facebook, etc. For them they challenged their challenge of the bill focused mainly on the Chinese threat, and there was a call for demonstration, and because of that, the National Assembly announced that they will postpone the bill. But even so, the demonstration took place across the country, and each demonstration involved from hundreds to thousands of Vietnamese people, and this is a rare incident in a country like Vietnam. And the bill was postponed until today. So the question is, why did why did Chinese actors become active in this case? And then why their attempts to transplant was unsuccessful? So Matthew has developed a general explanation for the hesitancy of the Chinese sector in transplanting transplanting law overseas. So basically, there are six factors. So that's the Matthew's theory. So number one is the regulatory capacity of China is still problematic. Number two is the relative nexus of the PRC legal system. Number three is the prestige deficit of the PRC law. number 4 is linguistic hurdles, and number 5 is the Chinese general reluctance to engage in the domestic affairs of foreign states, and number 5 is the agglomerate nature of the Chinese legal system. But in this specific case study, we see some of those factors that are relevant and explain why the two countries were why the Chinese became active in this case, and also from the Vietnamese side, the Vietnamese policymakers were excited, were interested in importing the Chinese model, as well as why those attempts was unsuccessful. So talking about the factors that facilitated the would-be transplant, we can see a number of factors here. The first factor is that from the Vietnam side, they see China as a model of success. They see Chinese SEZs as a successful story. So the successful story of Chinese SEZ has boosted the prestige of Chinese law in this case, and that creates an incentive for another country like Vietnam to consider to import Chinese law. So that's the first factor. The second is that even from the Vietnamese side, they see the importance of they want to attract Chinese investment, and actually among the actors that were most active in develop this kind of SEZ in Vietnam is the Quảng Ninh government, the province which is next to China and has a strong economic relationship with China, and that province was the most active in pushing this bill, and we can see that we can understand why they are interested in attracting investment from China. Yeah, and we can also see other.
Just concluding sentence. I'm sorry to have a little bit of time for Q&A, but thank you very much.
Yeah. Okay. So good time. We don't have time, so we can discuss about the factors that have facilitated the would-be transplant, as well as the factors that make this transplant unsuccessful. Thank you very much. Yeah.
So thank you very much indeed, the two of you, Matthew, for a tour d'horizon about the whole, let's say, geopolitical, geostrategic, geoeconomic landscape of the law as used by China in the region. And then a deep and very interesting dive by Hado on how, well, I understand China and Vietnam have a very, let's say, ambivalent relationship, and how legal cooperation, legal assistance fits into that picture, right? It's really a deep diving case study, and sorry for, let's say, disciplining you on the time a little bit, but I think it's really important to, after a deep dive, to already also get out again and then give the opportunity to our audience, and also I think the two of us, Jerome and myself, I have tons of questions. So I guess, Jerome, if you want to go first, and I'll check the chat for now, and we'll interact with the audience as soon as your questions appear here. Please feel free to address the two speakers in your chat Q&A questions.
Yeah, no, thank you very much. I mean, thank you both, and sorry for intervening on time. It's just to keep to 15-20 minutes for Q&A. I mean, a bunch of questions, but maybe to start with, so to the two of you, Matthew, at some point in your sort of macro presentation, you mentioned that in some cases it can be a strategy for China to keep sort of local legal system underdeveloped, and that it's sometimes striving to do so. And I was wondering if you had examples of this, and because it could seem quite risky, especially in terms of protecting property rights, in terms of anti-corruption campaign in China, in Vietnam, in other places. This seems quite potentially a risky strategy. So if you have thoughts about this. And on the Vietnam case, or more for her, I mean, it seemed you showed that Vietnam is actually a case, not a case of this, basically. It's a case where China is actually actively exporting its legal model, so sort of contributing to potentially further development. So, I mean, did I correctly understand there or not? Or is it, or can maybe the two elements, cohabit in the Vietnam case? So that would be an interesting question. And if Vietnam is a rare case where China is not trying to underdevelop, like how do we understand that? And especially in the context of the story you just presented, where the transplant, does not really function. So it can be also, it seems risky to intervene. So I don't know, just of course it's a very broad question, but if you have a few reflections on this, that would be great.
Yeah, thanks, Jerome. Let me just start off with that one, and then Ha can give his thoughts. So in terms of this idea of underdeveloping, I wouldn't say it's so much an intentional strategy. I think it falls under this category of sort of, the Chinese investors are very relevant to that host state jurisdiction. They're active in doing business there, and because of their business practices, because of the way that they're doing business, and the way that they're used to engaging with the formal law, that it can therefore have these sort of underdeveloped impacts on the local legal system. So first and foremost, what we find is, unlike the Americans, for example, Chinese are not interested in, for the most part, reforming legal systems, right? The Americans, starting in the 1960s, were very sort of evangelical in going out to Latin American countries and telling them, this is how you have an adversarial system, this is how you create your court structure, this is how you want to design your law school curricula to create commercial lawyers, right? That was the American approach. It was very sort of like instructional, pedagogical. Chinese don't do that at all. For the most part, if they could, they'd rather not touch the domestic legal system. And therefore, what we see a lot of efforts to create ways to, frankly, circumvent the host state law. So what's an example of that? Building international commercial arbitration, which famously, I mean, the Chinese didn't invent international commercial arbitration, but what it does is it provides a forum for dispute resolution, which is not in the local host state courts. So if the investor, in this case, the Chinese, have the perception that local courts are problematic, they're bureaucratic, they're corrupt, what have you, they don't want to get involved. So therefore, they bring their disputes to international commercial arbitration, which might be in Hong Kong, might be in Singapore, might be in China, could be elsewhere. So that's one aspect of the story. But the other dimension is because, the Chinese do have without unfairly generalizing, I think it's fairly fair to say that many Chinese businesses have a way of dealing informally with the law, shall we say? Okay, so that might mean working in a certain way vis-a-vis their counterparty that they'd rather settle outside of the formal legal system, or there may be certain business practices that are not wholly sort of above the table, rather they're below the table sort of business practices. And in the aggregate, these can ultimately sort of lead to the underdevelopment of a host state legal system, whether it's in the first category, the emphasis on transnational law and international commercial arbitration, you're reallocating resources from host state courts to, for example, arbitration centers, right? So that's a reallocation of resources. And secondly, the aggregate of sort of these informal practices can erode existing legal institutions, whether they're courts or prosecutors or what have you. So that's what that comment is about. But I think you're right that Vietnam is an example where we don't see that as much, although there could be examples of that. And Ha is writing a book on this right now, so he can give examples on that point if he sees them. But rather, we do see this interesting engagement. We see this interventionist approach through the SEZ bill, and also through the cybersecurity law, which also Vietnam had modeled after the Chinese version. I think the Chinese version was 2017, 2018, and the Vietnamese version was also around the same time. Ha can speak in more detail to that. But again, as we point out in the project, it's not simply the Chinese going in and telling the host state what to do. It's much more sort of this host state looking at China and seeing, oh, okay, so that looks helpful or promising for economic development, for anti-corruption, Jerome mentioned, which is another interesting story, in other areas, et cetera, and therefore we want to bring that into our own system. So, Ha, I don't know your thoughts on this point.
We can't hear you yet. Please unmute yourself, Ha. Yeah.
Sorry. Thank you, Matthew, and Jerome, for the very interesting questions. So, for the first question, Matthew has answered quite comprehensively. I just would like to add a bit to a point that Matthew has already pinpointed, which is unlike many other foreign investors, especially those from the West, Chinese investors they have they tend to use other informal mechanism to handle their business. So that can be one of the reasons why they are so far they are not very active in lobby for legal reforms in developing in recipient states. And this is from my experience, what I see from the case of Vietnam, because I talk with a number of local people from business association, from state agencies, and other actors. They often says that the Chinese, they are not very active in contribute their opinions to draft laws or things like that. And at the same time they have relied on other mechanisms to handle legal affairs. And I can give you a quite a very specific example. When I talk with an in-house lawyer who worked for a very big Chinese corporations, and he mentioned about a case in which his company lost in a case at a court, and because of that, company management decided to recruit to establish a legal department. So the first Chinese company within that reason to have an in-house lawyer. Although this is common in many other foreign companies, but for Chinese company to have an in-house lawyer, that's very rare. Although this is a very, very big corporation. So it decided, the top managers decided to recruit legal staff. But at the same time, they decide to strengthen relationship with local authorities. So what the lesson that they learn from their failure is that we need a lawyer, but at the same time, we need to strengthen relationship with local officials. So we can see that they don't see the law as the only means, or even a major means to handle their affairs, business affairs. So that's that. Yeah, I just want to add a little bit to Matthew's point regarding the second question. So Jerome asked whether Vietnam is an exceptional case in which China is active to export its law. I would say that generally the answer is no. So far, I don't see much effort from China to export law to Vietnam. But the influence of Chinese law on the Vietnamese legal system is significant. And most of the time, it's because, as I mentioned earlier, because Vietnam, they come to China as a model. Yeah.
Thank you so much to the two of you. That was very interesting. I have one question in the chat, which you can also see. And if you allow, I'd like to add one from myself, which is related. So Bill Hayton, one of the guests of today's webinar, asks, Vietnam and China are both run by Leninist parties. Can you address the extent to which the Communist Party of Vietnam wants to learn from its Chinese counterpart in order to protect one-party rule? And I'd like to add, if you allow, well, I'm also looking at the intersections of politics and law in China, and I think we know that law in China has a debatable status, right? They call it rule of law or rule by law, but there's a lot of party-state interference. And there was this amendment to the constitution in 2018 in China, which added the leadership of the Chinese Communist Party, not only in the preamble, in the preface of the constitution, but now also in the main articles and so on. So it's really about the calibration of party power and, let's say, the more Western liberal parts of the constitution, at least as a fiction. I just wonder how Vietnam has, to which extent, and this is coming close to question, Vietnam has copied Chinese model of a Leninist constitution, and how it has distanced itself. There was a new constitution in Vietnam in 2013, right? So how does the constitutional law relate to the Chinese model? Is it imitating or is it really deviating from that? I think this is all to you.
Okay, thank you so much. Yeah, very interesting and tough questions. For question from Bill, he's a very well-known expert in about Vietnam. Vietnam and China are both run by Leninist party. Can you address the extent to which the Communist Party of Vietnam wants to learn from its Chinese counterpart in order to protect one-party rule? To be honest, this is not a part of my research. But in our co-author article, I mean, with Matthew, we have a very brief discussion of Chinese borrowing, Chinese legal borrowing in Vietnam, and we pointed out a lot of examples in which the Vietnamese policymaker borrow from Chinese law, and in many cases the Chinese influence was modest, but in other cases the Chinese influence is significant. For example, in relation to land law, for example, Matthew mentioned cybersecurity law, and we also and we briefly commented that it seems that when Vietnamese policymakers need to address a new phenomena without sacrificing core Marxist-Leninist principles, like the socialist ownership of land, or how to control the society, cyberspace, or things like that, they tend to come to China more than other countries. So, but we also know that we need more evidence to support that. But it seems that when they need to like confirm party like very core principle, Marxist-Leninist principle, like party leadership, land, state land ownership, or things like that, they come to China. They come to China. And for Hague question about constitutional law, I'm not the right person to answer that. At Oxford, there is Professor Bùi Ngọc Sơn who has written a lot about this. But I could say that undoubtedly there are a lot of similarities between Vietnamese and Chinese constitutional law, and these similarities derive not only from Vietnam borrowing from China, but both countries had the root, the Soviet constitutional law. So in both countries, we see the recognition of party supremacy. We see the recognition of the principle of unity of power, or democratic centralism. So in both China and Vietnam, those principles, Leninist principles, are recognized in constitution. But the recent constitutional reform in Vietnam, which happened in 2013, why on the one hand it confirmed why it upholds long-standing Leninist principle, at the same time it adopts a sort of more like globalized Western language of constitutional principle, like they talk about human rights. So there is now a chapter on human rights. But the actual impact of that of those language is another thing. But anyway, we can see that they try to soften the socialist language, and at the same time they try to adopt a more global language of liberal constitutionalism.
Okay, very
so
interesting.
That's something that I can send you because Bùi Ngọc Sơn has written quite a lot about that. I can send you some publication on that.
Thank you so much. Thank you so much. That's really a deep dive again. And we have like to come to an end. If I may address Matthew for last time, and Jerome, if you have a concise question. Matthew, you had this very recent publication about China's dream of legal cosmopolitanism. It's in fact related somehow to what Ha just told us. What's your take here? Is there really a serious ambition of China to offer a concept of a more cosmopolitan version of law, at least for the region? That would be my last question to you. Jerome, do you want to enter?
Sure. I mean, I have a sort of self-interested question, but hopefully it can interest other people as well. Matthew mentioned in passing the United Front Work Department. And so in the realm of, I guess, in the legal realm, or I'm wondering, I mean, this is all about cooptation. So I'm wondering sort of if it plays any role, who are the targets, like law professionals in host states or things like this. Is it something that, that is relevant at all to the discussion of legal transplants and sort of circulation of law? And is there any connection? Because Matthew worked on religion in China before, and of course the United Front is.
We have 2 minutes to go, so rather let Matthew have the last word, and then
that's relevant. If that's relevant, if that's not, you can throw the question.
Thank you, Matthew. It's yours.
So thank you both for the questions, Jerome. I'm gonna toss your question out. It's a great question, but I haven't seen data that would speak to that particular issue, but it's a very interesting question. So this issue of whether or not China is building a cosmopolitan law, I mean, I think that's kind of the aspiration. It's very much designed against the Western approach, which is perceived to be not that, right? It's the US for the US, right? That's the idea. And in contradistinction, China is purportedly building out something which is much more inclusive, ecumenical, inviting of other communities, cultures, societies, particularly those in the global south, and including the region of Indo-Pacific, right? And where do we see this? Well, we see this, for example, in some of the institutions that China is building, where it is inviting experts from outside of China, people from, including in African states, to serve as experts in the International Expert Committee of the China International Commercial Court. At the same time, these institutions are not terribly active. And so my position would be that they're primarily symbolic, and it's a communicative function, right? They're saying that, look, here's what China is doing. We are building the South-South relationship through these legal institutions, but whether or not they're actually fulfilling the function of these institutions in terms of taking on disputes is a different thing, and to date they aren't. So the aspiration is there, the reality not yet.
Okay, thank you so much for your illuminating inputs and now your answers to questions of all of us. It looks like it's really very symbolically strong aspirations, but as you say, if you look at the life in the field, it's much more ambiguous and has a lot of informal and not so well functioning aspects too. With that, I want to extend my gratitude to all of you. Thank you very much. Hado in Melbourne, Matthew Erie in Singapore, Jérôme Doyon in Oxford today, with our best regards from the GIGA in Hamburg. And there will be another one on South African perspectives on the Indo-Pacific soon. Please check our websites, the GIGA website and the SERI website for the next event to come up soon. And with that, have a great day or evening, wherever you are. Goodbye, and thanks so much to all of you.
Thank you.
Goodbye, and thank you.
Goodbye.
Bye-bye.
Goodbye. Thank you.